Good morning, Your Honors, and may it please the Court, Brendan Duffy on behalf of Appellant Neil Grenning. I'd like to reserve 3 minutes for rebuttal. Your Honors, this case arises from prison officials censoring Mr. Grenning's attempt to publish a short story in a prison writing class. The story was approved by his instructors and recommended for publication, but officials blocked it from leaving the prison because it might lead to negative publicity, and later threatened to remove him from the program if he tried to submit it himself. The district court rejected Mr. Grenning's First Amendment claims at summary judgment, but it did so based on 3 key errors. First, the court applied the wrong legal standard. Outgoing prisoner speech is governed by Martinez, not Turner. This court said in Barrett v. Bellick that applying the wrong legal standard to outgoing speech is itself reversible error. Second, Superintendent Key's written threat to remove Mr. Grenning from the program for attempting to publish his story is textbook retaliation under this court's decision in Brodheim. And finally, the district court's errors go far beyond the merits. It granted summary judgment despite genuine disputes of material fact, failed to consider Mr. Grenning's timely opposition brief, and it denied discovery that would have revealed whether any policy actually authorized this censorship. In short, this court should reverse and enter judgment for Mr. Grenning on his First Amendment claims, or at minimum vacate and remand for application of the correct legal standard.
So counsel, you mentioned that the reason it was rejected is because of the reputational harm to the prison. It doesn't seem like the prison is defending that justification on appeal, and they're suggesting it's more of a rehabilitation purpose. What are we to do with that?
Your Honor, I don't think you can do that under Martinez. Martinez is heightened scrutiny. As this court knows, when we are doing heightened scrutiny, we look what the defendants in this case provide in the record. There's only 2 reasons for that the government provided in the record. This is ER 104. Ms. Weiss said she was attempting to enforce third-party publication criteria. And ER 113, this is Superintendent Key saying he was worried about negative publicity. Those are the only 2 reasons provided in the record. On appeal now, they say it was rehabilitation, but there's absolutely nothing in the record to support that. And this is not rational basis review. This is outgoing speech. And under Martinez, you don't get to invent post hoc reasons during litigation.
Well, is it an objective inquiry or a subjective inquiry?
Your Honor, I think it's a subjective. I think we have to look in the record. I mean, Your Honor, because Martinez involves tailoring, this is the same as the court does in other constitutional analyses. This is like in United States v. Virginia, where Justice Ginsburg said you can't invent post hoc rationalizations for things like heightened scrutiny. In rational basis, yes, we allow, and if this court thinks it's Turner, they could look to rehabilitation as a reason. But I think if this is and I don't think there's any dispute that this is outgoing speech. So I think Martinez applies. And I think if Martinez does apply, I think we have to look to the record. And even if this court is in Turner land,
yes,
this court's decision in Swift v. Lewis, I think, suggests that the actual basis still matters because 1, it might suggest pretext, or 2, it simply might suggest that there was no legitimate reason to begin with.
You know, as I understand.
So let me ask you.
Oh, go ahead, please.
Going under Martinez, in Martinez, it talks about any regulation or practice that restricts inmate correspondence has to be necessary to protect one or more of the legitimate government interests. And then they talk about those identified above that were specific to Martinez. In your view, what is the purported government interest that the prison offers here, other than reputation, which we've now
Your Honor, I think that proves the point. I think the only interest we have in the record is at ER 104 and ER 113, neither of which they defend on appeal. And I think that helps us for qualified immunity as well, because no reasonable officer would have thought these are legitimate reasons. In fact, they don't even attempt to defend those reasons on appeal, which I think helps our case. Now, what they do say on appeal is that it's rehabilitation. But again, I think we don't get to that inquiry. But even if we start looking at rehabilitation, I think that still fails for a number of reasons.
Let me ask you this. As I understand it, the prison concedes that if he were to send it to some other publication other than Inroads, he could do so. Is that right?
So I don't think that matters for a number of reasons, but I don't. To answer the direct question, I don't think that's clear in the record. So 1, I don't think it matters. So I think it fails the first half of Martinez. 2, on lesser restrictive alternatives, which your question goes to.
Well, no, that's not what my question goes to. My question goes to, well, if he can send it to other places, why can't he send it to Inroads?
because they barred him from doing so. I think
Maybe,
they
no,
would.
you didn't understand the thrust of my question. If he can send it to other publications, what's their justification for not allowing him to send it to inroads?
Oh, exactly, Your Honor. I mean, that was one of the points we made in our
Yeah,
brief, and I totally agree. The fact that them saying rehabilitation, it's unclear how rehabilitation could be triggered sending to inroads, but not to the New Yorker, for example.
And it's unclear how any of the other justifications
Exactly.
would withstand
Negative
scrutiny.
publicity as well. I mean, I think your point, the point I was trying to make on top of that point, Your Honor, which is, I think you read Superintendent Key's letter as a blanket ban. It's unclear why negative publicity wouldn't apply to any magazine. And again, then you plainly fail the second prong of Martinez. And I think any reasonable officer would know, again, when we get to the qualified immunity analysis, that you can't have a blanket ban on speech when Martinez requires the restriction to be no greater than necessary.
Go ahead, Judge McEwen.
Yeah, well, I don't know if inroads actually is distributed to the prison. In other words, if it's sent back, but would you agree that even if we take your point that they couldn't censor the outgoing mail and it could be published by inroads, that if the inroads publication came back to the prison, that they then would be able to impose certain restrictions?
Yeah, I agree, Your Honor. I do think that's a different inquiry. I think then Turner would apply. This is not, it doesn't involve the third-party interest, First Amendment interest that Martinez discusses. So if there was a restriction on, let's say Mr. Grenning did get his work published in inroads and the prison did not want it to come back into its prison and be circulated, that restriction would be analyzed under Turner. Now, frankly, I think that would fail under Turner as well because
isn't it true that if it is published in inroads, he's entitled to get a couple of copies himself? So that is to say, it would come back into the prison.
Yes, Your Honor, but that's not the policy restriction that we're claiming violates the Constitution.
Well, I'm just talking as a factual matter. It will come back into the prison.
Yes, Your Honor. I believe there's actually a question of sometimes they get the copies and sometimes they don't. I think there's a record question there, but again, the prison concede, or the defendants concede on page 2 of their brief that this content would actually not violate any internal prison rules as well, which I think goes to the fact that there is not a legitimate interest involved when it wouldn't violate the prison's own internal policies.
So counsel, to me, it seems like you're ignoring the fact that this is all part of a prison program, rehabilitation program. It's a writing program designed to help him get reintegrated into society. And so, I mean, for a number of reasons, that makes this distinguishable from Martinez. And you know, primarily, number one, you're saying that it's not in the record that it's a rehabilitative purpose that they restricted it, but saying that it doesn't comply with the writing guidelines of the magazine is a rehabilitative purpose. If they're trying to train prisoners how to comply with instructions and things of that nature, by saying it doesn't comply, that is, and rejecting it for that reason, that is a rehabilitative purpose.
So a couple of responses, Your Honor. So number one, again, just because it's part of a volunteer program does not mean that it doesn't have to adhere to Martinez. That's just an unconstitutional condition, right? They can't. The prison.
Well,
can't
it's
say
it's not a pure free speech argument. It is a part of a structured program that the prison is allowed to administer as it wants.
I agree, Your Honor. But I think that goes more to the interest prong of Martinez. There's a question of, is this outgoing speech? And again, everyone agrees that it is. The defendants concede in their brief that there is no control once it leaves the prison. The district court said this at ER 13. In fact, the defendants apply Martinez in page 46 and 47 of their brief. So I don't think there's any argument that we are applying Martinez here. And so then once we're applying Martinez, the standard is substantial interest no greater than necessary to serve that interest.
Yeah.
And the policy here, which again, it's still unclear what the actual policy is. It appears on appeal for the first time they're claiming that it is Ms. Weiss's unbridled discretion to block anything leaving the volunteer program and going to in-reason.
I mean, that it seems plausible that a prison administrator can decide when something meets the prison program's guidelines. I mean, are we supposed to like administer that? How?
I mean, under Martinez, if it is speech leaving the prison, it is heightened scrutiny. So if it's about,
that's right. That's why I don't think this is Martinez. I mean, a prison can administer a program, right? Say that the magazine is about like elephants, right? And you're supposed to write about elephants. And if he wrote about aardvarks, couldn't the prison program say this is non-compliant with the program, and so therefore I'm not sending it out?
No, Your Honor. I don't think if it is about, we would have to look at the first question is this Martinez? Is this speech leaving the prison?
Well, just answer my question.
So I don't think so. I'm not sure what.
So you're saying
legitimately
that if the
substantial
prison
interest would be.
program magazine is about elephants, that the prison he has a First Amendment right to send an article about aardvarks to a magazine about elephants?
Yes, Your Honor. I'm not sure what the what would be the. I'm not sure what the government
Because it
interest would be.
doesn't, then it's just totally defeating the rehabilitative purpose of the program. If the program is about writing, complying, and getting back, reintegrating into society, if he's not following the rules, then he's not, fulfilling the
But I
purpose of
think
the
that's
program.
getting the inquiry mixed up. The first question is whether it's Martinez. So if we're talking about Martinez, then we have to analyze it under this court's longstanding precedent on that case, which is substantial interest and no greater than necessary. So I think yes, there might be a situation where the interest goes down because it was a part of a volunteer program, which I think is getting to your point. And I agree that the interest might be changed because it was in a program. But that doesn't mean it's not outgoing speech. And that the important part that Martinez made clear was it's triggering First Amendment interests of a third party. That is the important First Amendment interest. They actually said, yes, of course, the prisoner has First Amendment interests, but the interest that we are concerned about, the reason it's triggering heightened scrutiny is actually because of the third party interest that is that the outgoing speech is being sent to.
Whose interest are you?
So in this
The
case,
magazine's interest?
so it'd be the magazine. It'd be any again. It would be any person that you are sending speech to. So in this case, it might be Claire Wilson, the editor of Inroads.
They're trying to vindicate Inroad Magazine's First Amendment interest?
That is part of it. It's both.
Can't be right.
It is both. Well, I think the
Well, first of
Martinez
all,
is
if
very
that's
clear
true,
about
then the prison didn't stop Inroads. I mean, has no authority over Inroads Magazine.
Yes, Your Honor. The question is, can they screen?
Yeah.
And they didn't.
Yeah,
They sent it to Inroads.
Can I interject a
Well,
question?
but
Because
the policy is still
your
on
time.
Time is running out.
Yeah, your time is running, and I'd like to ask a question.
Yes,
My
Your Honor.
colleague suggested that this would be inappropriate in the magazine because of its sexual reference. My understanding is that the magazine Inroads actually does publish things with sexual references, and that this would not necessarily be inconsistent with that. Is that correct?
Yes, Your Honor. I don't. I think the argument that again, I don't think we even need to reach that because I don't think that's the reason was in the record. But if we reach the question of was this a children's magazine and what kind of stories were published, I think this is the exact opposite of a children's magazine. There was stories about rape. There's a parental advisory notification. So
Right.
yes, Your Honor.
It appears that
So
this is.
would it even matter though? Because the right is really the prisoner for the outgoing mail, and Inroads could decide yes or no, we'll publish.
Yeah, sure.
Yes, Your Honor. The question is at the time of screening, and again, I think the policy is on the books. Getting back to Judge Bumate's point, it's the question of what is the prison blocking from leaving. What happens later is not part of the inquiry. So I just want to make that point clear. I'll reserve the remainder of my time for rebuttal.
Just
Wait,
before
sorry,
you
unless
Answer
there are
your
more
question.
questions.
Yeah, we'll give you more time if you
Okay.
need. Go ahead.
Okay, I just have one question, and I know you'll get a little bit extra time. What is the clearly established right vis-a-vis the qualified immunity question?
Your Honor, so I think it's Martinez, and I think for all the reasons that I said, and I can talk a bit more about
All
that.
right.
But again, I want to make one just procedural point on that. That again only goes to the damages claim for the censorship issue. Even if we lose on qualified immunity, we still have injunctive and declaratory relief, and they don't make a qualified immunity argument as to retaliation.
Okay. Any more questions? Okay. Thank you,
Thank you,
counsel.
Your Honor.
Good morning. May it please the court. Assistant Attorney General Michelle Young on behalf of the defendants here. This case is not about censorship and retaliation. It's about safety and rehabilitation. The Department of Corrections does not prevent inmates from complaining about or reporting anyone or anything to people or entities outside the prison. But when the department permits a voluntary rehabilitative program to be held inside its prison, it has the authority to impose regulations needed to keep people safe, the institution secure, and participants progressing toward rehabilitation.
Assuming that rehabilitation and safety are justifications that had been advanced at a time when we can now consider them, how does this make this prison unsafe?
So it makes, there are two different issues here. The first is the screening of Mr. Grenning's short story and the sexual content. That goes to the rehabilitative purposes.
I asked,
Does-
how does it make it unsafe?
The safety issue goes to his contacting Claire Wilson, who was a student volunteer. And there is a serious, important government interest in preventing volunteers and inmates from developing improper relationships.
Wait a minute. Where'd that come from? I think we're talking about two sentences in a story.
No, this is, so Mr. Grenning, Superintendent Key's letter to Mr. Grenning was in response to Mr. Grenning violating the policy and writing directly to a student volunteer. That was prohibited. It had nothing
That
to
is to
do
say,
with
when
the
you say
content.
writing to the volunteer, that is to, when he sent the story to Inroads? Is
Yes.
that what you're referring to?
Yes,
Did he do it in person or did he just send it?
he sent it through the mail.
That's correct. So he didn't say, it wasn't as though he had physical contact with this person. He just sent it through the mail.
Right.
Okay.
That's prohibited. And
And why is that then a safety proposition that he sends something through the mail?
so the safety proposition is that he's developing, potentially could be developing an improper relationship with Ms. Wilson. The volunteer policy.
And was there
Where
anything?
does it say that? Where in the record do we look on that?
About, I'm sorry, what part of that? Are about the policy or about, so Superintendent
Well, the
Keyes-
implications of the policy that Judge Fletcher was discussing about, well, you just said there would be a potential improper relationship. Where is that articulated?
Okay, so that is in the volunteer policy, which is in the record. And hold on just a second, I'll get you that reference. And then it's also in the volunteer handbook, which is also in the record. This is in Superintendent Key's letter, ER 113, which specifically talks about that that this letter is in response to Grenning, and Superintendent Key is very concerned about the fact that Mr. Grenning had written directly to a volunteer, which is prohibited.
I did see that in the record. The one thing though, it was on the volunteer side. There was nothing in the record that shows that prisoners are prevented from contacting volunteers. Is there any?
We don't have that in the record. I think there is a policy, but it wasn't in the record because that wasn't an argument that was made below. However,
And you want to put it in the record and make the argument now?
no, we're basing it on the policy that is in the record. We're basing it on the volunteer handbook. We're basing it on the syllabus, which tells inmate participants that they are not allowed, that they cannot contact the volunteers. If they have any questions, they need to be asked in class, that they're not to be asking them
Point me to
outside.
where, what we do have in the records, they're not supposed to contact volunteers?
We have it that they're, that
Can
in
you-
the,
can
in the
you-
context of
Ca-
this class.
Can you
yes.
point me to the language that's in the record?
It's in the syllabus,
Can
and
you?
it just says,
No, I'm asking you, where is the language? I'd like to read it.
so the language is in the syllabus.
I know, what is the
But
language?
what record reference?
He's asking for like an ER site.
The ER is ER 101 through 103, and the reference says, if you have any questions, be sure to ask them in class. We can't ask or answer any questions outside of the class context.
Well, that's really not this case. And I mean, I go back to Ms. Wise' paper, this little yellow piece of paper. And initially she says, due to the sexual content, this writing submission is inappropriate for publication in inroads that includes distribution to minors.
Right.
So-
So we've got two issues. We've got the
Right,
issue
so I
of
want to go back
Wise's
to,
greeting.
let me ask my question if I might. So going back to that first issue, and I understand there's that issue plus the other that you've pointed out, but going back to that issue, in effect, Ms. Wise is deciding in advance that this is not appropriate for publication inroads, which is not really her role, but she's kind of acknowledging that this is outgoing mail to inroads. So it seems to me that she's really directly invoking Martinez and then putting herself in the position of being an editor at inroads, isn't she?
So we have, the record is fairly clear. It's implicit, but it's clear that that inroads, that Claire Wilson and inroads were on the same page with respect to the standard here. So we have ER 123.
No, but that's not the point. We don't even know if it met the standard or not. It's not the prison's decision on the outgoing mail. It's inroads, and it may or may not be published, right?
Right. So, but this was, so the screening requirement, there was a standard that was imposed in this class. In the context of a class, this is not a prison-wide policy. It's in the context of a single class. And in this class, the standard was no sexual content. And we know that from the publication.
How does that advance a rehabilitative purpose?
Because inmates, we're trying to make them better neighbors when they get out. They need to understand boundaries. They need to understand compliance with procedures and with standards. And in this case, Mr. Grenning did not comply with that.
So you're suggesting that because it's in a prison program, there's heightened standards because they're trying to train heightened like mores or rules for society.
Right. So the Department of Corrections doesn't have any interest in making their inmates better creative writers.
You just said that there was a policy that there's no sexual content for any of the writings, irrespective of whether it's sent out. Where do you find that?
That just in the context of this class, and we know
So
that.
So what's the basis for that statement that you just made?
The basis of the statement is that we've got the publication agreement, which is ER 106. We've got Claire's.
I'm not talking about publication for the moment. I'm asking you, because I heard you say, maybe I misheard you, but I heard you say it was inappropriate to write anything in this class that had sexual content.
No,
Is
they
that what you said?
They could write it, but they couldn't discuss it, and it was not to go to inroads.
So they couldn't discuss it in the class?
Exactly.
And so where's that policy stated?
That is in ER 120.
And could you read me the policy?
1 through 122.
Could you read me the policy?
The policy, it is an email from Ms. Wise to Claire clarifying the standards, the behavioral standards.
Is-
No
oh,
explicit-
no, that's in
not a
respect to,
policy.
that's in respect to this case. What's you have to be talking about a pre-established policy. Is there any
Well,
pre-established
it
policy?
wasn't pre-established with respect to this class. And
And,
that
and where was
email-
it pre-established?
The email was sent before this litigation.
And read me the email?
I'm sorry, what was that?
Could you read it to me?
Yes. Ms. Wise is clarifying that there's to be no, I think she says no violence.
You're
no-
not reading it to me.
Well, I don't have it memorized, Your
Oh,
Honor.
well, and you don't have it in front of you?
I don't, I have
Okay.
I have the site.
I
It's
I
ER
can
121.
I can find it. Okay.
Okay, thank you, I'm sorry. Here, we've got a prison class that involves an educational program, voluntary, and so the prison situation here, this is not a blanket policy. This is not a blanket outgoing mail restriction. Grenning could have submitted his story to literally any other publisher in the world. He had that opportunity. He sent it to one of the few people he was not allowed to write to, and it had nothing to do with his story at that point. Superintendent Key was very concerned about the fact that he had written to a program volunteer, a student, and the prison policy restricts the interaction, and because of the reason of the potential for development of an inappropriate relationship, which jeopardizes institutional security, volunteer safety, and
So the one problem with that is that that was not articulated by the warden at the time.
well,
So what are
he
we supposed to
does-
do with that?
he does link his concern directly to Grenning's contact of the volunteer. So we know that. The language, I do have that language.
Well, I don't recall that. If you
Yeah, so I do have that language. In that language, Superintendent Key says, you stated in your letter that you had to send your story directly to the university. This causes me concern as you have bypassed our processes. Policy does not allow for volunteers to accept any correspondence without prior approval. If you send any correspondence directly to a volunteer again, without prior approval, you will not be allowed to participate in this volunteer program.
so he directly cites the safety.
Right. He makes that a direct link.
Okay.
Now,
And then, but the other reason he cites was the reputational harm, and you are not defending that on appeal,
no,
correct?
no, and he actually says that's Wise's job. He's trying to explain to Grenning what Wise's role is. Now we know that Wise had a lot greater role than that because we have her job description, but we also know that that Wise did not restrict it based on, she did not reject it based on negative publicity. She based it on the sexual content, which aligns with all these other things that we have coming in and going out from inroads. And so Mr. Superintendent Key did make that statement, but it was only in the context of this one class.
Had he
But
sent,
how do you square that then with the record, which documents Inroads publishes on more than one occasion a number of stories or submissions that have sexual content?
So the publication agreement says that mature themes and adult language are usually okay, but that explicit content is not. And we would say that here we've got explicit content in that it's a description of a sex act, whereas talking about a rape or talking to somebody who's been a victim of a rape is a mature theme, not explicit content. And the university felt strongly enough about this proposition that they made all the authors sign the acknowledgement, accepting the fact that explicit content was not appropriate for their population, their audience. And so
isn't that a decision ultimately to be made by Inroads? I mean, the story can go out and it either does or doesn't meet those criteria. Isn't that an Inroads determination?
So this is not Wise making the determination. This is Wise so the standard was set.
No, my question, maybe it's a yes or no question, and then you have an explanation, but isn't ultimately the decision as to whether or not a submission meets the Inroads criteria, isn't that a decision to be made by Inroads?
Yes, but with respect to whether or not an inmate is violating the standard, that is a rehabilitative purpose that the Department of Corrections is screening for. So it's not about Wise deciding what's going to be in Inroads. It's about Wise saying, this is the standard that we set. We told you no explicit content. You included it, so it's coming back to you.
now,
She didn't prevent it from going out at all. It still went out.
what if he had sent it out to some other publication? Would that have
It
been?
would have been fine.
That'd have been fine. So he could send it any place,
Any
any
place
publication
else.
except
Yes.
Inroads.
He could send it to Playboy, for example.
I'm sorry, what was that?
He could send it to Playboy.
He could have sent it to he could have sent it to Highlights magazine. But the issue here is this is a class. The department has a rehabilitative interest in the class. That's the reason they allow it to be held inside the prison, which is a security risk. And so they were trying to teach Mr. Grenning boundaries and compliance with standards.
And talking about the rehabilitative process because it's in the prison, tell me again whether or not it was inappropriate for him to have written this. I'm not yet talking about sending it out. Was this inappropriate for him to have written this in the class?
No, I don't think so. I mean,
So this is okay to write.
he could write,
The only problem is that he wanted to send it to this magazine.
and it didn't comply with the program standards. So it
But
didn't
you're
comply
saying-
with the
But
class.
if the program standards are talking about rehabilitation, how can he write it in the first place? What gives him the leeway to do that?
Well, because he has the leeway to write whatever he wants to. The question is whether or not it's appropriate for the class, right? So if I'm an instructor in a class and I tell my students to write about a certain thing, and I tell them to exclude this content, they can write whatever they want to, but I'm not going to accept it for credit. And here we've got the screening process. Mr. Grenning circumvented that. Mr. Grenning included content. And so Ms. Wise returned it to him. Now, he sent it out. It went through the mailroom. It was not.
Counsel, your colleague on the other side said that this rehabilitative purpose was not presented below. Do you agree with that?
The rehabilitative purpose?
Yes.
No, well, and you have to remember that we're dealing with a narrow record below because the inmate didn't make a lot of the same arguments that they're making now.
Oh, I see.
So to the extent that the I believe that we did make the argument below that there was this rehabilitative purpose and that there was an important interest in establishing boundaries and compliance with regulations. And I believe that that was made in our argument below. But like I said, we were kind of dealing with, it's a little bit iffy because our record below is so narrow, and we haven't complained about the fact that they've expanded their arguments. We think that
Okay.
that's inherent in appointing counsel. But
Would you also, just for our benefit, submit a 28J letter as to where below this rehabilitative standard was put forth?
it would have been in the motion for summary judgment.
No, I meant if you would submit a 28J letter and then it gives you a little time to look up the specific record site, that would be useful.
I would be happy to do that.
Thank you.
Thank you, counsel.
Thank you very much.
We took you over. We'll give you 3 minutes, please.
Your Honor, just on the rehabilitation point, I will say, I think they did generally refer to rehabilitation, one of the filings below. I was more making the point it was not in the record as to the actual, not a waiver point and more a point that it was not in the record for the justifications given by the
see.
prison in advance. So I'm not, she can still submit the 20J, but I wanted to clarify.
Thank you.
my
That's
point
helpful.
there. Yeah.
That's helpful.
On the Claire Wilson discussion, I just want to make 2 points. One, I don't think it's clear in the record that she is actually a volunteer. I believe in ER 172, or 174, Mr. Grenning claims she was not a volunteer, but I think, and so I'm not, she might have, had some oversight capacity, but I'm not sure if she was an on-the-ground volunteer. At least that was not made clear in the record. But two, I think that's an opposite. So I think everyone agrees that these prisoners can submit publications to Inroads. They were provided the publication agreement on ER 106, and it directly provides Claire Wilson as the name and the person for who they're supposed to submit them to. So I'm not sure how that's a violation of any policy. Either she was not a volunteer and it wouldn't have applied, or she was a volunteer and she plainly was exempted from that policy. So whatever that is, I don't.
Yeah, she's identified as WITC student director. Now, that means she's a director of students, or maybe she's a student who's a director. I don't know.
Yes, I agree, Your Honor. I'm not sure that's clear in the record. And again, on ER 106, they're directed to submit, any questions, inquiries, and I believe the publications themselves to her. So she would be exempted from that. The other point, back to Judge Bumate's question, I just want to make clear. I agree that if this was Airway Heights Correctional Facility paper, it would be a different inquiry entirely. But again, no one disagrees that this is outgoing speech, and so then there's a different standard that we're applying. So
I agree with that. My distinction is really that it's part of a program, a rehabilitative program, and that gives them a little more leeway in that respect.
So I agree. Your Honor, I don't think it can be the case that. I think then it just becomes the unconstitutional condition question, which is if you sign up for this program and you want to send out any speech, we can block you for any reason. That's essentially what
to the program's magazine. Yes.
Well,
what's wrong with that?
Again, but Your Honor, these are sort of somewhat distinct entities, and this goes to the Martinez question. No one disagrees that this is a third party. So we are applying Martinez. They've conceded that, and so I think
I have to ask if that's true.
I think we're mixing around the inquiries.
I think they've conceded it's a third party. I don't think they've conceded it's Martinez.
Yes, Your Honor. I think Martinez answers that question. And then lastly, Your Honor, this question of the policy that was being discussed. Again, I don't think they've ever pointed to a specific policy. I think that is still unclear in the record, and I think that certainly helps certainly at least in the as applied challenge. And then lastly, Your Honor, if this court has any concern, I would point them back to Barrett v. Bellick, where this court remanded at least for the district court to consider Martinez in the first instance where they had only made Turner arguments below.
Thank you, counsel.
Thank you, Your Honor.
And thank you for your pro bono representation here. Both sides did a fine job.